Imagine you are driving down a quiet suburban street. The sun is just dipping below the horizon, casting long shadows across the asphalt. You see the familiar flash of red and blue in your rearview mirror. Your heart skips a beat. You instinctively reach for your license and registration, and yet, something in the back of your mind whispers, "Wait, don't step out yet." Have you ever wondered why so many seemingly simple traffic stops escalate into tense confrontations? Why routine stops sometimes end with citations, arrests, or worse, even when you know you haven't done anything wrong? Take a moment and think. If you were pulled over right now, would you know exactly what to say and do to protect yourself legally without risking escalation? Drop your thoughts in the comments below. Your experience might surprise others. Across the United States, millions of traffic stops occur every year. According to data collected by the Bureau of Justice Statistics, law enforcement officers conduct over 50 million traffic stops annually. Yet the majority of Americans have little understanding of their rights during these encounters. Most of us have been taught to comply automatically. Hands on the wheel, window down, documents ready. But the law is more nuanced than that. There are legal principles rooted in the Fourth Amendment, court decisions, and decades of case law that define what officers can and cannot do, and what you are legally obligated to do in your vehicle. Consider the history. The right to be free from unreasonable searches and seizures has been enshrined in the United States Constitution for over 2 centuries. But the way this right applies during traffic stops has evolved through landmark Supreme Court decisions. Cases like Terry v. Ohio, 1968, established the concept of stop and frisk and set parameters for what constitutes reasonable suspicion. Later rulings further clarified the boundaries between lawful police authority and individual civil liberties. Today, this framework dictates every interaction between you and a police officer on the road. Yet despite these legal protections, misunderstandings are rampant. Simple missteps, like reaching for a glove compartment without informing the officer or attempting to exit the car prematurely, can inadvertently be interpreted as noncompliance or even resistance. This is where the advice of experienced legal professionals comes in. Lawyers across the country have repeatedly emphasized that knowing the right words to say and when to say them can make the difference between a calm, lawful stop and a potentially volatile situation. Think for a moment. What if a single sentence, calmly and clearly stated at the right time, could protect your rights, reduce tension, and ensure the stop proceeds according to the law? It is not about confrontation. It's about knowledge, clarity, and respect for both your legal boundaries and the officer's duties. This isn't theory. It is grounded in real-world examples. Consider the 2015 case of State v. Johnson, where a driver's careful, measured communication with the officer prevented what could have escalated into an unlawful search. The courts later cited the driver's clear assertion of rights as a key factor in the ruling. Over the next hour, we will explore exactly what you should and should not say during a traffic stop, how the law interprets your actions in the vehicle, and why stepping out at the wrong moment without the proper legal framing can expose you to unnecessary risk. We'll break down the key legal principles, share historical cases that set precedents, and provide real examples from lawyers who have defended clients in situations that could have gone completely wrong if handled differently. But first, let's address a common misconception. Many people believe that refusing to exit the vehicle is automatically considered defiance. In reality, the law recognizes your rights as a passenger or driver. Court rulings have consistently emphasized that officers must have either probable cause or a valid command under state law before requiring you to leave your car. Misunderstanding this distinction is at the root of countless escalations. So the question is, do you know the exact moment and the exact words that legally empower you to maintain your rights safely? Think about it and share your guess in the comments. You might be surprised by the answer. Throughout this video, we will use a combination of legal analysis, case studies, and practical examples to illustrate why these details matter. From the historical roots of your Fourth Amendment protections to the nuances of modern traffic stop procedures, you will gain a comprehensive understanding that most drivers never learn in driver's education. By the end, you will know not only what to say, but also the reasoning behind it, so you can act confidently without fear of violating the law or escalating a routine encounter. Traffic stops may seem mundane, but they are complex legal interactions, and knowledge is your best defense. Over the next segments, we'll guide you step by step through the do's and don'ts, the historical context, and the exact phrasing recommended by lawyers to maintain your rights while remaining fully compliant. Every phrase, every pause, every action has a legal weight, and understanding it could protect you in ways most drivers never consider. So, before we dive deeper, take a moment to imagine the next time a police car lights up your rearview mirror. Picture yourself remaining calm, informed, and fully aware of your rights, knowing exactly what to say, exactly when to say it, and exactly how to act in a way that is legally defensible. That moment, that preparation, is the difference between uncertainty and control. As the red and blue lights reflect off your dashboard, the tension you feel is real, but it is also manageable. The key is understanding the legal framework that governs this encounter. In the United States, the Fourth Amendment protects citizens from unreasonable searches and seizures, but its application during traffic stops can be nuanced. Officers are permitted to stop a vehicle if they have reasonable suspicion of a traffic violation or criminal activity, and once the stop is initiated, they have certain powers, but those powers are not unlimited. Let's break it down. When you are pulled over, the officer's initial questions typically focus on identity and compliance, license, registration, insurance. These are routine, but the law distinguishes between what the officer can ask and what you are required to provide. For example, while most states require you to hand over your driver's license when requested, you are not obligated to answer questions unrelated to the stop, such as, "Where are you coming from?" or "Where are you going?" unless the officer has a legal reason to ask. This distinction has been affirmed in numerous court rulings, including Hebel v. 6th Judicial District Court of Nevada, 2004, where the Supreme Court clarified the limits of compelled identification. Now, consider the moment most drivers overlook, exiting the vehicle. Many people automatically assume that stepping out when an officer approaches is either polite or required. In reality, courts have repeatedly emphasized that the officer must have either a lawful command or a justified reason to require you to leave your car. In the landmark case of Pennsylvania v. Mims, 1977, the court held that an officer could order a driver to step out of the car for safety reasons during a lawful stop, but that authority is specific and limited. Understanding when you are legally obligated to exit versus when it is optional is critical. Here is where the advice of experienced lawyers becomes invaluable. They consistently emphasize that a simple, calm, and precise phrase, delivered before you move a muscle, can clarify your legal position without provoking confrontation. This is not about arguing or resisting, it's about asserting your rights in a way that the law recognizes. By verbally acknowledging your compliance while preserving your legal boundaries, you set the tone for a safe, professional interaction. For instance, consider the case of a driver in Florida in 2018. The officer approached the vehicle for a minor traffic infraction. The driver remained in the car and calmly stated, "Officer, I am happy to provide my license and registration. I am remaining in my seat unless instructed to exit by law." This simple phrasing immediately established two things: cooperation with the officer's lawful requests and a clear assertion of the driver's rights. The officer proceeded without incident, and later legal analysis confirmed that the driver's careful wording reinforced the legality of his actions. Think about it. How many people assume that remaining in the vehicle will automatically escalate the situation? The reality is that the law often supports the decision to stay put, provided your communication is respectful, clear, and compliant with what the officer is legally allowed to request. Knowing exactly what to say, and in what tone, transforms the encounter from a tense guessing game into a structured interaction governed by clear legal principles. Now, let's examine another crucial aspect: searches of the vehicle. Many drivers are unaware that an officer cannot search your car without either probable cause, consent, or a specific exception defined by law. Common exceptions include situations like the presence of weapons, evidence in plain view, or lawful consent. This is where phrasing matters. By clearly stating your boundaries, "Officer, I do not consent to a search of my vehicle," you are legally preserving your rights without escalating conflict. Courts have repeatedly recognized that non-consent does not constitute obstruction, and asserting this verbally can be pivotal if legal questions arise later. Historical cases provide valuable context. In Florida v. Bostic, 1991, the Supreme Court examined consent in bus searches, emphasizing that voluntary, informed, and uncoerced communication is key. Translating this principle to traffic stops, it becomes clear that verbal clarity and respect are not just polite, they are legally meaningful. The words you choose can prevent misunderstandings that lead to citations or arrests. But knowledge alone is not enough. Timing and tone are equally important. Lawyers advise that the moment an officer approaches your vehicle, you pause, make eye contact, and speak clearly. Avoid sudden movements, avoid reaching into compartments without explanation, and always prefix any statements with acknowledgement of compliance. For example, "Officer, I am happy to provide my documentation. I will remain seated unless you instruct me otherwise." This accomplishes three objectives simultaneously: cooperation, clarity, and protection of rights. At this point, you might be wondering, isn't this just common sense? And yet, statistics show a different reality. According to the Police Executive Research Forum, misunderstandings during traffic stops are a leading factor in escalations, even among law-abiding drivers. Small missteps, like a delayed verbal response or ambiguous body language, can be interpreted as non-compliance, triggering unnecessary tension. This is why a prepared script, mentally rehearsed and legally informed, is so valuable. Before we move further, ask yourself, if you were pulled over tomorrow, would you know the exact words that communicate cooperation without surrendering your rights? Think about your last encounter with law enforcement. Did you speak up? Did you remain calm? Or did uncertainty guide your actions? Comment below. Your reflection can help others understand how these principles apply in real life. Over the next segment, we will explore step-by-step scenarios, including what to say when the officer asks you to exit, how to handle routine questions, and how legal precedents shape the exact wording lawyers recommend. We'll also examine case studies where careful communication made the difference between escalation and smooth compliance, giving you a practical blueprint for your next encounter.